Bill C-22 poses a serious and unacceptable risk to the privacy rights of Canadians, both as an individual right and as a social right essential to participate meaningfully in democratic discourse. The Centre for Free Expression's work is premised on understanding that democracy is a regime founded on ongoing public discourse as to what is legitimate and what is illegitimate in society, a discourse which is necessarily without any guarantor and without any end, a discourse in which we all have a right to participate and to be informed. Privacy is fundamental for freedom of expression and democratic discourse, specifically what Neil Richards has termed intellectual privacy, which is protection from surveillance or interference when we are engaged in the process of generating ideas, thinking, reading, discussing with those close to us before our ideas are ready for public consumption. In our evolving digital world, much of our reading, thinking, and private communications are mediated by electronic technologies that make possible unprecedented forms of surveillance by the state, digital platforms, marketers, and even those in our social networks. The right to privacy is recognized as a human right in international law that Canada has signed and ratified. It is also enshrined in the United Nations 1948 Universal Declaration of Human Rights that Canada supported and endorsed. While Canada's Charter of Rights and Freedoms does not mention privacy specifically, our courts have made clear that Section 8 protects privacy. In R.V. Spencer, Justice Cromwell wrote for a unanimous Supreme Court that, in paragraph 15, this court has long emphasized the need for a purposive approach to Section 8 that emphasizes the protection of privacy as a prerequisite to individual security, self-fulfillment, and autonomy, as well as to the maintenance of a thriving democratic society. Further, at paragraph 36, he writes, the nature of the privacy interest does not depend on whether, in the particular case, privacy shelters illegal or legal activity. The analysis turns on the privacy of the area or the thing searched and the impact of the search on its target, not the legal or illegal nature of the item sought. And finally, at paragraph 41, he writes, there is also a third conception of informational privacy, the understanding of privacy as anonymity. In my view, the concept of privacy potentially protected by Section 8 must include this understanding of privacy. In R.V. Marica, Chief Justice McLaughlin discussed the privacy implications of modern electronic communications. To quote, preservation of a zone of privacy in which personal information is safe from state intrusion is the very purpose of Section 8 of the Charter. This zone of privacy extends beyond one's own mobile device. It can include the electronic conversations in which one shares private information with others. It is reasonable to expect these private interactions, and not just the contents of a particular cell phone at a particular point in time, to remain private. Bill C-22 is the latest in a long string of proposals to undermine Canadians' right to privacy in the name of fighting crime and protecting national security. While all rights are weighed in by our courts in light of the competing interests and priorities, the proponents of Bill C-22 have lost sight of the priority our Charter and our courts have given to protecting expressive freedom and hence to the privacy rights that help make political expression and democratic discourse possible. Bill C-22 will also supercharge state surveillance by, first, establishing a new low-threshold production order under the Mutual Legal Assistance in Criminal Matters Act, so foreign entities may submit a request to the Minister of Justice for the production of transmission data or subscriber data that is in the possession or control of a person in Canada. To be granted, the request must only meet the low bar of reasonable grounds to suspect. There is no dual criminality requirement, meaning the foreign offence need not also be an offence in Canada. Next, creating the framework for Canada to ratify the second additional protocol to the Budapest Convention, a multilateral data sharing treaty that attempts to expedite the speed and volume of data sharing between foreign law enforcement agencies at the expense of human rights. Third, making possible a Canada-US cross-border data sharing agreement, which Canada is currently negotiating with the United States under the US Cloud Act. As the Citizen Lab's Kate Robertson has written, this will mean, and I quote, U.S. surveillance activities covered by the agreement would no longer require oversight from Canadian authorities or judges, thus relinquishing a core element of Canada's sovereignty under international law. And finally, the Supporting Authorized Access to Information Act, which through both public regulations and secret orders, would allow the government to require the broadly defined category of electronic service providers to make wide-ranging and drastic modifications to their systems to facilitate access from law enforcement threatening encryption. It will also require all ESPs to retain sensitive personal data about users for up to a year without adequate safeguards to protect against security vulnerabilities that such orders will create. The new regime would also lack adequate accountability or transparency provisions. Thank you, and I look forward to your questions.